Hi, Amanda.
Hi, Josh. What are we going to talk about today?
I want to talk about the intersection between workers' compensation and various employment laws that allow for leave from work. So let's imagine this hypothetical. Employee gets injured on the job, they can't work, they apply for workers' comp, it's preliminarily approved, they're temporarily totally disabled, they have no work capacity. They apply for FMLA leave, which provides up to 12 weeks of unpaid job protected leave. They exhaust that leave, and the employer says, "Hey, can you come back to work?" Employee says, "No, I can't come back to work yet." And employer says, "Well, it's been 12 weeks, so you're fired." What can employee do there if an employee has been injured on the job, they're going through the workers' compensation system, they've exhausted their FMLA leave, but they're still not able to return to work the way they were before the injury?
This is tough stuff, and we see it quite a bit. And there's a lot of laws at issue that are triggered, frankly, at various points throughout this hypothetical timeline that you gave us. So let's talk about a couple of quick things. The first, when you're out on that FMLA, that 12 weeks of paid leave that you just, excuse me, that 12 weeks of unpaid leave that you just referred to, Josh, make sure if you are a Connecticut employee, you also at the same time apply for CT paid leave. You may very well be entitled to some compensation through CT paid leave. It doesn't extend your period of protected medical leave, but it does put some money in your pocket. Now, if you're at the same time receiving workers' compensation benefits, there may be an issue there. But sometimes, Josh, in your example, you said that the claim was temporarily approved. Some folks are out from a workers' comp injury for a long period of time, and that claim's denied. So they have no money coming in at all. So CT paid leave, of course, would be a good option for them and would keep some money coming in. If you are receiving workers' compensation benefits, you might not also be able to receive the CT paid leave benefits at the same time. Obviously, talk to a lawyer about that, or just go right on CT paid leave and apply and see if those benefits get approved. So that's step one. Now, back to your original question, Josh. What do? We exhaust this 12 weeks, whether it be paid or not, through CT paid leave or what have you, and you can't go back to work. What do you do? The first thing I would suggest doing is requesting a reasonable accommodation for just a little bit more protected time off. What does that mean? If you've been out for 12 weeks, it's very likely that you're suffering from a disability under either Connecticut state law or federal law. If that is true and you have a disability under either of those statutes, then you could request a reasonable accommodation. A reasonable accommodation could be so many things that we've talked about on these videos before. Maybe you have a bad back and you need an ergonomic chair. Or maybe you need a little bit more time off to be able to get back to work and perform the essential functions of your position. That's a reasonable accommodation request, too. You have to do a couple of things. Talk to your doctor about it, right? You're going to need a medical note that says, hey, Josh needs another X period of time off, and he's going to be reevaluated on Y date. So you need buy-in from your doctor. You also need to communicate that request directly to your employer and say, I'm looking for reasonable accommodation of blank. Okay. The other thing that's super important is what is this amount of time that you're looking for? You want to keep it as short as you possibly can. Don't go over 30 days. If you say, I need another 6 months off, that's unreasonable, right? We can't expect employers to just hold jobs open in this protected status for an indefinite period of time. So keep the time frame as short as you possibly can to increase the likelihood that your employer will say, all right, you know what? This is something that we could work with short term. At the same time you're doing that, find out whether or not your employer has a short term disability policy. Because if you've exhausted all money and you're not receiving those workers' compensation benefits, this is going to be a tough time because you're an injured employee and you have nothing coming in. So you want to look at those short term disability benefits as well. The most important thing that I can stress is talk to an employment lawyer. There are wonderful workers' compensation lawyers in the state of Connecticut who are so good at what they do. The intersection, though, between our workers' compensation statutes and all of these employment laws is tricky, right? You might get fired, and that might trigger a lawsuit under the FMLA. It could trigger a lawsuit under the Americans with Disabilities Act, the Connecticut Fair Employment Practices Act, Section 31290A of our Connecticut workers' compensation statutes. And you might be saying, Amanda, my head is spinning. There's just so much to think about. And there is. So if you're going through something similar, You're not alone. We deal with a lot of Connecticut employees that do. Just make sure, in addition to having great workers' compensation representation, you talk to an employment lawyer and you do it quickly. Sometimes we could actually save people's jobs before they get fired, which is great. But you have to have an opportunity to do that.
Amanda, that's all really helpful information for folks who are dealing with an injury at work and are out of work while they're applying through the workers' compensation system. But I want to make sure we answer the really fundamental question, which is if I'm hurt at work, I cannot go back to work in the 12-week period. Maybe I get a short extension for a reasonable accommodation, maybe I don't. But at the end of that, I still can't go back to work. Can I be fired? I mean, I got hurt at work. How could they just fire me after I got hurt on the job?
The easy answer is, yeah, they can fire you, Josh. It's no different at that point whether or not you were hurt on the job or you're dealing with a cancer diagnosis, right? That has absolutely nothing to do with your work or your employer. If you exhaust that 12 weeks of protected leave, your employer no longer has to keep that job open for you, period. So a lot of people say, but wait a minute, this wasn't my fault. I got hurt at work. I didn't do anything wrong. How could they fire me? Unfortunately, the law allows them to do that. Now, there are exceptions to that. There are ways that we could try to work around that. You could go to your employer and say, look, I can't do X job anymore. Is there something else I can do? And you can try to have that dialogue with them and be practical and come up with a reasonable solution. But the truth is, your employer could say, no, Josh, I'm sorry, that's not something we can do. If you can't return to this job within those 12 weeks, or at the conclusion of those 12 weeks, rather, your employment is terminated, and they can lawfully do that, which is why it is so important to chat with an employment lawyer, because is there a workaround to that? Is there something else that you could potentially do that could save your job? The goal isn't always to have a lawsuit, Josh. You and I both know that. The goal sometimes is, I just want to go back to work. How can I do that? And outside of just having a lawsuit, there might be ways and mechanisms that you could do that if you're working with an employment lawyer. And then, unfortunately, sometimes you just can't.
I'll add one more wrinkle to this discussion, Amanda, which is that employees who are hurt on the job need to be sensitive to whether they're being treated differently than other disabled employees who were not hurt on the job or who were hurt on the job but didn't hire a lawyer to help them in the workers' compensation system. Your
Yes.
employer cannot treat you any differently because you hired a lawyer to represent you in comp than they would if you had not done that or if you had been hurt outside of work. You're protected from workers' compensation retaliation under Section 31-290A of the Connecticut General Statutes. So if your employer has created a light duty job for somebody who got hurt outside of work playing basketball, but they're not creating a light duty job for you when you got hurt on the job, that's something to talk to an employment lawyer about.
That's such great advice, Josh. I'm so happy that you raised that. I hope your head's not spinning from all of this, but this is just a great example of how facts matter, and each person's situation and their job and what their employer could and could not do really impact what happens here. So it's important to talk to somebody and try to work all that out and get to the best solution that works for you and hopefully for your employer as well. Thank you so
Thanks
much
so
for
much for
watching.
watching. We'll see you next time.